It's my honor now to introduce our next panel. You'll recognize our first panelist here, Mr. Archie Rabinowitz. He's certainly been a previous presenter, but more than that, he's actually been an important anchor of the continuation of this program, and I'm sure you'll, if you take a chance to ponder through his bio, his expertise on the subject area that we're dealing with this morning is par none. Archie Rabinowitz is a partner with the firm Denton's and is a certified specialist in estates and trust estates litigation specifically. We haven't reproduced it all here, but I saw his lengthier bio in the, I took note of our previous speaker's experience in trial and appellate work, but the list of cases that he's been involved in is simply remarkable and goes to the expertise that he represents. He's also the author of many articles and important texts, reaching out, speaking to lawyers, professionals, and of course the public on many relevant topics for us today. He's represented a wide range of clients, from trust companies to government agencies, and of course individuals dealing in the contested passing of accounts, the validity of wills, estate claims, breach of trust, undue influence claims, interpretation of wills, appointment and removal of trustees and guardians. The list goes on. He's he has deals with the Canada Revenue Agency. He's the lawyer of choice for the Law Pro organization. And he's, of course, received many well-deserved recognitions, some of which are highlighted in his bio. I'll take note of one or two. In 2008, he was the recipient of the Ontario Bar Association's Whitfield Award, and he also has acted as chair of the Prestigious Law Society's annual Summit on Trusts and Estates since 2008. We also have this morning Rabbi Torczyner, and he's a return visitor whose insightfulness we've really appreciated to our estate and trust discussions. Rabbi Torczyner is has been the Rosh Beit Midrash of the Yeshiva University Torah Mitzion Beit Midrash Zichron Dov since its founding in 2009. Before that, he has been the spiritual leader of congregations in the United States and has sat on the executive committee of the Rabbinical Council of America. What is remarkable about his bio, I think, is the way he's able to specialize in the blending of different areas of knowledge, utilizing diverse methods to develop curricula in a range of topics: Jewish history, Tanakh, Jewish law. You can find more than 450 recordings of the rabbi's lessons, the shiurim, that he's delivered since his arrival in Toronto, and you can find them at the yutorah.com. He's a regular contributor to the Center for the Jewish Futures to Go publications. And throughout his career, we've seen from him a specialization in groundbreaking Hebrew educational material. Since 1995, he's pioneered a website that I can also refer you to, WebShus, which offers topic-driven index to the Talmud, and another website, Hamakor, bibliographies on a wide range of topics that I'm sure many of you will find interesting. He also maintains something that I read now and then, a popular blog, The Rebbitzins' Husband, which I like the title. So we welcome both our speakers, our panelists this morning, on the subject of using the Beit Din, the Jewish courts, as an alternative in this type of litigation. Thank you.
You sure? Yes. Okay, I'm first then. Thank you very much, Anita. Thank you, Charles, for inviting me. Excuse me. I want to thank Bnei B'rith and the sponsors as well as Archie for being my tutor in how to sit on one of these panels. I'm not a professional dayan, a judge on a Beit Din, on a Jewish court. My interest in the topic tends more towards the academic, but I was asked to talk this morning about whether Beit Din, based in the Jewish court, is a viable option in estate litigation. So from the perspective of an observant, practicing Jew, so Beit Din is supposed to be the choice, that's supposed to be the venue where cases are litigated between Jews. Even though we are taught, and I covered this in depth in the paper, I'm only going to summarize briefly now, but we're taught within Judaism, the dina de malchuta dina, the law of the land is the law, that in fact there are 7 commandments that are given to every human being, and one of them is to create a legal system, and we're supposed to honor the legal system of the society in which we live. Nonetheless, Judaism also tells the Jew, you're really supposed to take your case to a Jewish court. And this is because Judaism tends to see the practice of justice not only as a mechanism for governing society and keeping people safe, but also as a religious duty. And if it's going to be a religious act, then it should be carried out in a religious context. And there are a few different ways to look at it, and again, I spell this out in the paper. One way to look at it is that going with another legal system is tantamount to accepting another ideology, another religious ideology in place of a Jewish one. Another point that's raised is that going with another legal system will endanger the continuity of the significant percentage of Torah, of Jewish teaching and law, that's devoted to the civil code. When you look at the Talmud, which is sort of the foundation text for so much of Jewish law, more than 25% of it deals with civil code issues. And if I can just turn to the local authorities, then I'm not going to study that, and that will quickly atrophy and die away. And then a third, since we view the practice of justice as a religious duty, going with another legal system effectively means losing my opportunity to do what's called a mitzvah, to fulfill my obligation. It wouldn't be any different from missing a chance to participate in a Passover Seder, fasting on Yom Kippur, all these things that are identified as religious acts within Judaism. Justice and following the Jewish legal system is one of them, and therefore it's not to be missed. So from the standpoint of an observant Jew, I'll say, well, not only is Beit Din a viable option, it's where I'm supposed to go. Having said that, when I've discussed this as a topic with lawyers before, I've heard 3 reasonable concerns about going to a Beit Din. Concern number 1, is the hearing going to be fair? What if I have a case in which one party is a known member of the Jewish community and the other one is an outsider, maybe someone who's not personally observant, maybe somebody who lives elsewhere, doesn't know the people involved, doesn't know the judges? Will there be a fair hearing? Number 2, will the judges understand the complexities of the case? Perhaps we're dealing with a complex estate, and the question is, do they have the training to really understand the issues involved? And then number 3, will the judges, working with an ancient legal system, provide a result that makes sense today? And I think all 3 of these concerns can be addressed within the Beit Din system. Going back to the first concern, is the hearing going to be fair? So there is something within Jewish legal proceedings called Zabla. Zabla is an acronym for Ze Borer Lo Echad, and what it means is that when 2 parties want to go to Beit Din, they don't have to choose a specific standing court. Rather, each side, I should preface, a normal Beit Din, a normal court for handling civil matters, has 3 judges. So what you can do is have one party choose one judge, the other party choose a second judge, let the 2 judges choose a third between them, and that's your Beit Din, and that's your court. And because you have somebody you have actually selected, the hope is, you will have someone you know and you trust who will be involved in selecting that third judge and will be involved in hearing the case. And this is something that's already brought in the Talmud 2,000 years ago. It's been a practice ever since. And the philosophy of it simply is that we need to have the trust of the parties involved. If you're going to tell people you have to go with that particular municipal court, then you won't necessarily have everyone's trust. And so the goal here is to win over the trust of the participants by letting them have a share in helping to select the judges. So that's one. The second concern was the concern that the details of the case may be complex and require expertise. Maybe the people who are qualified to serve as dayanim, as judges, don't have the technical legal training to really understand what's involved. So number one, I would say don't underestimate those who have this training. It's a fairly rigorous process to become a dayan, to become a judge. But aside from that, there is the ability to accept those who are not formally judges as judges on a particular case, meaning that litigants can say, you know what, we respect these dayanim, we respect these judges, but we actually know so-and-so, the estate lawyer, and we think that he has good grasp of the issues, and we'd like him to sit on our Beit Din. We would like him to be on the court. In fact, all three judges can be such people. They can be lawyers. There is a requirement that they be Jewish in order to avoid the problem of appearing to go to a legal system that's not the Jewish legal system. But then they don't have to have the strong rabbinic training. They can have the strong legal training. And again, the idea is it's the importance of being able to trust them. The third of the three concerns is the concern that the law won't lead to a good solution for the parties involved. And so here we can employ the principle called pshara. Pshara literally is rendered as compromise. And the Talmud discusses our approach to what could be called mediation, arbitration. I'm not going to use the words because I know they have technical meanings, but we call it pshara. The Talmud discusses the possibility that the litigants can be presented with a solution that is not letter of the law. And in fact, the Talmud has three different perspectives on this. One view is the view that it's a violation of justice. You're supposed to have justice, let justice pierce the mountain, and that's it. The second view is that it is permitted to go with a pshara system, this sort of compromise approach, until the judges know what the law ought to be. Once they know what the verdict should be under the law, then it's a perversion of justice for them to take another system. But the third view in the Talmud, which is the view that is accepted as law, is that it is a mitzvah. That not only are judges allowed to recommend some kind of a settlement, but it's actually what they are supposed to do. They're supposed to look towards a settlement. So I'm going to quote Maimonides doing a quick translation. He says it is a mitzvah for the judges to say to the litigants at the outset, do you want justice or do you want compromise? And if they want compromise, that's what the judges should do. And any court, I'm still quoting Maimonides, any court that practices compromise perpetually is considered praiseworthy. The Code of Jewish Law is even stronger in its expression. The Code of Jewish Law in the beginning of the 16th century wrote, judges are responsible to distance themselves to the fullest extent possible from imposing justice. They're supposed to instead opt for compromise. And there are various theories as to why a system that has such a strong push for justice would really suddenly shift and say, no, we actually want compromise. Rabbi Leo Kramer, also known as the Vilna Gaon, at the end of the 18th century, simply said it's because we don't consider ourselves wise enough to apply strict justice properly, and therefore we figure if we can create a compromise that the litigants will accept, we're safer. Rabbi Avram Yitzchak HaKohen Kook, a leading rabbi in Israel in the beginning of the 20th century, said it simply because justice is often too harsh. He compared it to the natural elements. He said the sun shines, and it's good for most people when the sun shines, but some people are going to suffer. And so it's true for any legal system. He says laws may work well for the majority of people, but they aren't going to work well for everybody. And so he says just like when you're dealing with the elements, if you end up in a situation that's uncomfortable or harmful, you have to try to protect yourself from them. So too, when you're dealing with a court of law, Rabbi Cook wrote that it is not only acceptable but appropriate for us to come up with a way to protect the litigants from the law effectively by coming up with a compromise. So what we have here are the three concerns: the concern for a fair hearing, the concern that the details might be very complex and require special training, and concern that the law won't lead to a good modern solution. And you have three responses to that within the Beit Din system, such that indeed cases can be brought before them in a sensitive way, a way that will both respect the existing Jewish legal system and work with the needs of the parties involved. Last point: in the event that the other litigant won't go to Beit Din, let's say I am the plaintiff and I want to bring somebody to the Jewish court, and the defendant doesn't want to go. And indeed, the Jewish court says, we're going to issue a summons, and the defendant says, well, I'm not going anyway. So at that point, there are options for the Jewish plaintiff to say, well, then I have no choice but to resort to the secular court. I put in some details about this in the paper that you have in the binder in front of you, but I just wanted to mention that the option does exist.
Rabbi, I just want to veer a little bit off our regular schedule, and I'd like to pose the following scenario to you. Husband and wife make normal mirror wills. Husband gives everything to wife, wife gives everything to husband. They have two children, a son and a daughter. Fast forward now, where both mom and dad are in a nursing home. Son lives in the city. Daughter lives outside the city, and it's incumbent on the son to visit the parents and take care of them. Son goes to his father, and he's the only one who visits him, and he says, Dad, there are forced heirship rules al pi halacha, in accordance with halacha. Everything should go to me, al pi halacha, in accordance with Jewish law. You made a will giving everything to mom. Unless you change your will right now, I'm out of here. You're never seeing me again. You're going to die alone. So, arguably, that's something that we will call undue influence, and we have a case in the secular courts. But if the Orthodox, and if dad dies after he makes the new will, and daughter comes as an Orthodox Jewish woman to Archie Rabinowitz, and she says to him, will I win in secular court, or will I win in a Beit Din, because I should go to a Beit Din? Arguably, she has a better chance in a secular court. What advice does the rabbi give to a solicitor or a litigator like Archie Rabinowitz, and to the daughter about her obligation to go to Beit Din?
Excellent question. I would divide it up into two different points. One, the son's interpretation of Jewish law, which I think is really sort of beyond the scope of what we're going to talk about today. Is he correct that these wills don't work? A lot depends on how they're structured. But second, the main point that you raised, the undue influence issue. So within Jewish law, compelled gifts are not valid. The term that's used in Jewish law is ones. If someone says, I'm going to give a person a gift, but does so because of some kind of duress, then any finding that the gift was given under duress is sufficient to cancel the gift. It gets a little bit more complicated when the person who gives the gift receives a tangible benefit, because at that point it's really more like a sale, and it's harder to say that a sale was invalid due to duress. You received something after all. Perhaps you agreed to that transaction. So there, Rabbi Yechiel Michal Epstein, writing in his Aruch HaShulchan in the beginning of the 20th century, he suggested that in a case where there is a benefit received by the giver, but the benefit does not rise to the level of being of reasonably equivalent value, then you can make the argument that it's basically a gift given under duress and cancel it on that basis. Let me just take it one step further. Let's say it is of equivalent value. Let's say the case that you gave, the parent was in fact in major need of help, in major need of care, and the child is providing great care on a regular basis, but the child makes that contingent on the design of the bequest such that it will all go to that particular child. So there, we would require some kind of written statement from the parent saying, I am doing this, I am rewriting the bequest under duress. If the parent made such a statement, it's called a moda'ah in a Jewish court, then indeed the gift will be canceled. That rewriting will be canceled. Absent any sort of proof of their intent, because they did receive something and it was something of equivalent value, we'll say that their rewriting stands. That's my basic understanding. Again, I want to note, as I said at the beginning, I don't serve as a judge on a court, and I'm academic in this, but that's my understanding.
But isn't it fair to say that your explanation doesn't address testamentary gifts, which are gifts through a will? Because al pi halacha, according to Jewish law, a person cannot give something away once he's dead through a will.
Right, but then I'm fine either way, right? Because as you said to me last year in this room, you can't sit and stand at the same time, right? Either you're going to tell me that the bequest given after death is invalid in the eyes of Jewish law, in which case there's nothing to discuss because the second is as invalid as the first, or you're going to tell me that it was given in such a way that it will be a gift inter vivos or something along those lines, but it's depending on how one designs a will to satisfy Jewish inheritance law, it comes out to being some kind of a gift before the person passed away, in which case this rule does apply.
So I'm using this as a segue to give whatever little time we have left to Archie.
Carry on.
Suppose it's a testamentary gift which may be set aside in a secular court, and the old will would apply, but the Beit Din, applying Jewish law, would say the new will is okay because it's basically putting into place the forced heirship laws of halacha. What obligations does the litigant have to knowingly go to lose to Beit Din, the Jewish court? And what obligations does a ultra-Orthodox Jew like Archie Rabinowitz have when the client comes to him?
So you're not asking the undue influence question anymore. You're now asking a separate question.
It's still undue influence, but it's testamentary undue influence. But the Beit Din, won't the Beit Din just say, even though it may be undue influence, it's compliance with forced heirship laws, so that stands? So
if you're asking, and I'm restating because I want to make sure I understand the question, if you're asking a particular Jew is an heir to an estate which has a will, and he has the choice of going to Beit Din to deal with disputes over it, in which case the will will be ignored and the standard pattern of inheritance will be followed, or can go to a secular court where the will be upheld and they'll get a much better deal. The question is he entitled to go to a secular court in order to get a better deal than he would get in Beit Din?
Yes.
So my answer would be that, number one, he doesn't have the option of saying, well, I would like to ignore my religious obligations in order to get a better deal for myself. There are many other areas within Judaism where I could also say, if I just ignore this, I will be economically better off. And that's not something we do. However, I noted before the possibility of working with a pshara system, working with a compromise system. It would certainly be within his rights to go with the other, potential heirs, whoever else this is being litigated with. It would certainly be within his rights to go with them to a Beit Din, but to appeal to the judges for pshara and ask the judges to take into consideration the fact that had he gone elsewhere, he could have gotten whatever it is that the will would have granted him.
So let me throw the ball to you, Archie. How would you handle that type of situation? Before I
try to answer the question, I just want to rely on a comment that Brendan, I think, was referring to, that no reasonable person would ever believe the truth of the statement that he could bench press 250 pounds. No reasonable person would would believe that I was an ultra-Orthodox observant Jew. But in any event, leave that aside. That's, I suppose, for another day in another court. I start off by reminding myself and everybody that we have, as lawyers, whether we're observant in any religion or not, we have rules of professional conduct. And one of them is that we have to ensure that if we're not qualified to take on a case, and if we have any ethical or moral dilemmas which prevent us from providing clear advice within the ethical standards which are mandated by our governing body, I think the general consensus is, and one of the papers that is in your materials by, I think, Professor Resnikoff of DePaul University College of Law, at the end of his paper, he concludes that we have a duty to either withdraw or, in my case, just decline to take that on in the first place. So, having never spent a moment in a ecclesiastic court of my life, at least to my knowledge, and I'm exhausted just listening to the discussion, because Dr. Freud would, if he took Amex, would still be raking it in, shall we say. In any event, I have no expertise in offering any views, informed views, on whether or not an ecclesiastic court is a viable option or not. But I do have many instances where observant clients, mostly in Judaism, but not always, have come and asked the question to me, am I going to get a fair hearing? I'm concerned that if I fulfill my religious obligations to take the other litigant to an ecclesiastic court, that there's no predictability, that it's a complex case that involves issues that even the secular courts have difficulties with. And Rabbi Torczyner admirably and I think eloquently explained that there is greater expertise in the Beit Din than perhaps that comment might have suggested, but again, I can't confirm or deny. However, I don't hesitate in reminding the client that if by their inference they're assuming that a secular court is going to be a court where we can make a reliable prediction of the outcome of this complex case, all I need to do is refer to them to a couple of recent cases where the courts have commented on the applicability or the crossover between religious principles and secular principles. So with that set up, I just wanted to give you a quote from a case. It's I don't even know how to pronounce this, Launer and Banub. It is a 2009 decision of Justice Gonzalez. And the quote is, "The court is cognizant of the religious beliefs that motivate the applicants and the respondent, Ms. Banub, in relation to this matter. The law is clear, however, that such religious laws or beliefs are not a factor that the court may take into consideration. Ultimately, it is up to the estate administrator or trustee to assume the obligation to dispose of the deceased's remains in an acceptable and dignified fashion." So you can extrapolate easily what the case was about. So that is a partial, and I literally mean partial, response to the question that you put to me, Chuck. And then we also have, just as one might get excited and say, well, we can with certainty tell our client that, with all due respect to your religious beliefs, my religious beliefs, the judge's religious beliefs. There's no room for that in the court, only to be followed by the more recent decision of Justice Carol Brown in a case called Friedberg v. Korn. That was a case, the facts aren't really relevant to the passage that I was going to take you with, but the passage in that court is the relevant quote. The evidence was clear that Mrs. Friedberg was a devout adherent to the Orthodox Jewish faith and that her religious values infused every aspect of her life. The evidence is clear that throughout her life she adhered to the beliefs and values of her faith and instilled them in her children. While it is possible that Mrs. Friedberg could have intended to deviate from her long-held views with respect to end-of-life decision-making, as it was found by the board, it's a capacity and consent board, it is highly unlikely that it was her intention, given the consistent evidence regarding her level of religiosity and her decision to appoint her 3 children raised by her in strict Orthodox Jewish upbringing as her attorneys for personal care. So in that case, we have a completely conflicting view about the role of the religious beliefs of the client. So I sort of tell clients that, look, I can't help them resolve their moral or ethical or religious dilemmas, but if you're going to make an informed decision about whether to pursue your remedies in secular court or in Beit Din, and it's a delicate line to walk because we have to be respectful of both courts, to be honest with you, no matter what our views or our clients' views may be about the quality of the sophistication and training and background and experience of the judges in a 3-judge panel in the ecclesiastic court. There's no predictability as to where a court's going to draw the line in the secular courts as to whether the roles of one's religious beliefs. So that goes to this whole issue of, I think, Charles's fact situation might have been an easier one to resolve because of the rabbi's comments, but it was being set up really as a straw man argument. But there are shades of gray to that fact situation where it's less clear, and I'm always pointing at these inconsistencies out, and I don't mean them to say that one is right or wrong, but don't for a moment think that the secular court, even if the argument is how are they going to understand the ecclesiastic judges, how are they ever going to understand and appreciate the nuances of corporate oppression remedies or fraudulent conveyances and the other topics that Greg spoke about. I remind them that that's not the only issue, that there are many other issues before one makes a decision. And just before I conclude, I do want to thank the Rabbi and Chuck for one specific thing. I was thrown out of Talmud class so often, as Charles was kind enough not, and Anita was not, did not mention in a far too embarrassing intro and description of my bio. The last time that I was thrown out of a legendary Talmud teacher that Charles and I had, we were actually covering the portion of the tractate, I think, that the rabbi referred to in his paper on Sanhedrin that talked about this concern, this rule that an Orthodox Jew shouldn't take another Orthodox Jew if they've got a legal dispute to the secular court for the reasons which, with some exceptions, of course, which the rabbi covered off. And the last time I got thrown out, I asked the question, but what if a Gentile insisted that he wanted to litigate in the rabbinic court? Of course, I didn't ask it as respectfully as I just put it this way, but I unsuccessfully tried to defend the question, and I was vindicated, I think, because footnote 13 in Professor Resnikoff's paper which I think is in the materials,
Yes.
actually quotes that very question by, I would assume, a very distinguished rabbi, but again, just demonstrates my ignorance, Rabbi Shimon Duran, and literally asks that one question and concludes that the Jewish litigant cannot resort to a secular court. So I don't feel that bad for having been thrown out after all. Anyways, thank you very much.
If I can add several quick comments. First of all, I know of a friend of mine, some of you may know him as a real estate lawyer, Rudy Brady, who went to Beit Din and won successfully. The rabbis in the Beit Din, although their training is not necessarily in secular law, are very bright, very sharp, and very capable. I, for one, don't feel that going before them, you would lose that the expectation of excellence that you would want to go before a court. It's there. The other thing I wanted to point out, because I'm often asked this question, is estate planning for Orthodox Jewish people. Again, I don't do estate planning, but because I'm reputed to have some familiarity with halacha, it's there, and we are including a paper as tab A to this paper, a paper by Donna Littman and Stephen Resnikoff, who are professors in the United States and have graciously agreed to submit it. It is a worthwhile read for anyone who's dealing with estate planning for Orthodox Jews. And in particular, I want to point out on page 190 a response by Rabbi Moshe Feinstein, who arguably was the greatest halachic decider of the 20th century, where he points out, and he's in the minority opinion, because, when we have three Jews together, we have five opinions. He's in the minority opinion, but he states that a secular will is a valid will. And when in accordance with Jewish law, and when I broached this to Professor Resnikoff, he explained that I didn't understand what Rabbi Feinstein wrote, but I'll leave it to you when you read his paper. The second thing I wanted to point out is in tab B, is the litigator's moral dilemma when he has a Orthodox Jewish client coming to him and say, I insist on going to Beit Din. And Professor Resnikoff, who is also a rabbi, addresses it in his second paper. It's a worthwhile read. And I'd like to just end with this thought. Whenever I'm faced with that dilemma, I'm always concerned that by the time the matter gets to Beit Din, the money is gone. You haven't served your client well. I may be doing my duty as an Orthodox Jew, but I am shirking my duty as a lawyer if I'm advising a client to take a path that will lead him to lose everything. So often what I do is I get the rabbi on the phone, I speak with the client, and I insist that I will only take the case if first we go to court to freeze the money and then agree to arbitrate the matter before the Beit Din. It's just my way of dealing with it. I don't know if it's the right way, I don't know if it's the left way, but I suggest it might be the possible compromise, because otherwise, if you're taking on a file to hurt your client, I suggest you refer it out. Thank you. Yes.
There's a fourth reason why I, as a family lawyer, have issues with referring to the Beit Din, and that is the change in the Family Law Act back in 2007, which prevents arbitrations that don't conform with Ontario law. So if, somewhat as you were saying regarding the issue of freezing the assets, my issue would be going in good faith, both parties going in good faith to the Beit Din, for an arbitration, not for mediation, where there's a decision made and somebody doing the math, or in child custody, but more even just on property or support issues, somebody doing the math and saying, I could do better, and then going to civil court and saying, yes, I entered into an arbitration agreement with the Beit Din, but it's null and void on its face. And I've actually had that situation, and so it denigrates the Beit Din on the one hand. On the other hand, it creates uncertainty for the parties because now they have a baseline which not necessarily will be found in Ontario law. So would that be a good enough reason, the unenforceability of a Beit Din award, other than perhaps the community-based enforcement? Because I can imagine through the ages, many communities didn't have enforcement through the civil mechanisms to avoid going to Beit Din at first instance.
Right. So I was thinking about that question as I was speaking before and wondering about the impact of the Family Law Act. And I think that odds are, and I'm saying odds are carefully here, but I think odds are that a Jewish court, a Beit Din, would find that as reasonable justification for pursuing in the civil court. Because as you said, this isn't the first time in Jewish history that Jewish courts have had enforceability issues. And we do have precedent for using that as a reason for pursuing in civil court. Yeah.
And although I'm not a family law lawyer, the only thing I would add, and it led to yet another expulsion of me from chat, was no doubt the husband who was refusing to deliver the bill of divorce, the get, wasn't rational, and doesn't someone just go out and beat the heck out of him so he comes to his senses?
Thank you. Professor Oosterhoff.
Yes, thank you, Charles. I'm not going to ask this of Archie because I was never kicked out of Talmud school as he was, so I'll ask it of Rabbi Mordechai. But first, a comment. It's many years ago now that I did a review of a book by a Jewish rabbi and lawyer, I believe, on the Jewish inheritance laws that you spoke of, Charles, which was revealing to me and very interesting. So now I've heard all about the Beit Din, and I found that very worthwhile and academically interesting. But I have one question, and perhaps it's more of academic interest to me than of practical interest, but that is this. Do you permit lawyers to appear before the Beit Din?
That's a very good question. Historically, you didn't have the phenomenon of a lawyer. The judges were responsible to figure out, based on the evidence, what the claims would be and so forth. But as a modern phenomenon in Beit Din, we do in fact have them. They go by different names, a To'ein or Din, whatever. But yes, in many modern courts, you will find people functioning as lawyers, as agents on behalf of the litigants. Mm-hmm. There are courts that are uncomfortable with this system of having the lawyers because they're afraid that it can lead to things being presented in a way that will confuse the issue. They're concerned about claims that will make things fuzzier rather than more straightforward. But it does exist in various courts, yeah.
All right, thank you. One other point. The reason I was never kicked out of Talmud school, as Archie knows, is I'm a Christian.
That wasn't reason enough.
Pardon?
Pardon?
But there's an interesting point I wanted to share with you, and that is in what Christians call the New Testament. There's also a statement made by the apostle to the effect that you should not take your brother to a court of law, which means a secular court, in other words. We don't have, as Christians, Beit Dins, but there is a similar kind of
concept.
Right. Actually, if you look at the paper that I put here, I had Paul doing that in Corinthians. He has the requirement, and also among Muslims in the Quran, you have they're enjoined to pursue their disputes before believing Muslims. So indeed, it's not unique to Jews, but I think in general you see it, certainly in Western religion, the idea that pursuing justice is indeed a religious matter and is therefore meant to be pursued in a religious forum. Yeah.
Last question.
On a practical point, if a client, before he drafts a will, consults with a rabbi, and the rabbi gives him the inheritance laws of the Torah, and the firstborn has two shares, the daughters may not get anything, etc., and then he goes to a lawyer, and the lawyer tells him, well, if you write the will that way, you may find yourself with dependent relief issues and all kinds of stuff. But again, he drafts the will in accordance with his rabbi's recommendation. Can a secular court set aside that will on the grounds that we spoke this morning, or do they respect the fact that this will is in strict accordance with Jewish law?
Before addressing the question of how a secular court would look at that will, I do want to note that within Jewish tradition, going back to the times of the Talmud, the girls did get. The daughters were first in line from the estate for their support, and then only if there was something left did the sons get. So I wanted to make sure just to mention that point.
But to be clear there, that's not asset transfer, that's support.
Correct. But now in terms of what a secular court would do?
How much insurance does the drafting lawyer have? I think to answer the question would be foolhardy for me to do, given there are so many red flags that go up. If a lawyer doesn't warn a client, actually, I think we're duty-bound not to take those instructions. There's numerous cases that indicate that lawyers are not scribes. It's no defense to say, but I have a written direction, instructions from the client to go ahead and do this. Now, even that, there are probably some exceptions. For example, if a patient or a client was in palliative care on the eve of death and there were no other alternatives, it's not like you could tell the client, go look up another lawyer who's got more insurance. God only knows what a court would do. But my crystal ball's been broken since the day of my practice, so I wouldn't be able to tell you what a court would do. I would just simply say the advice that I would give if the lawyer came to me, which wouldn't be pretty.
Even though it's in strict compliance with Jewish law, you would not go. And yet, the rabbi certification that this is the way the law goes, you will still not draft that will. I'm with Chuck. I don't draft any wills, but if a colleague who is competent in drafting wills came to me with that fact scenario and said the justification for taking those instructions was because the rabbi has certified that it's in strict compliance with religious law and no other explanation, I would tell them then Brendan Donovan really can press 250 pounds.
I would just like to add one thing. It's, with respect, you're not asking the right question. The question is, what does the client want? And how does the drafting lawyer comply with that request and complying with his professional obligations? So, for example, if you want to comply with Jewish law, you can comply with Jewish law if you make an inter vivos gift. It's your property, you can do it. As long as you don't run afoul of the protection we've put in as Canadians with respect to the Succession Law Reform Act and with respect to the Family Law Act. So the trick isn't just to say, my rabbi said. It's not enough. The real question is, what is the testator's intention? And how do we carry out those wishes? And one thing about halachic wills, There doesn't exist such a thing, because a will is a testamentary document. The halachic will is the use of inter vivos type transfers, acknowledgments of debt, so that you don't run afoul of the forced heirship laws of halacha. So when a lawyer calls me for that advice, I say, as long as you don't sue me, I'll tell you the following. Find out what you have to do to comply with halacha. Find out how you can do that so you don't run afoul of the tax issues, so you don't open the executor up to a lawsuit. For example, one of the halachic mechanisms is that you give a gift that takes place immediately before death. You're the executor. You take the will. It says the gift is given before death. Did the gift, you helped me out on one of these things. Did the gift take place before death? Then why did you go and pay probate fees? You're liable. So don't do this alone. Go to a professional estate planner. Don't dabble. Do it in conjunction with the rabbi, and do your job as a lawyer. Carry out the instructor's intention, the testator's intentions, but do it in a way that it's inter vivos.
I'm actually I have a follow-up question actually I think it's for Kim from her panel before.
Kim?
I'm sorry, this may be a question for you, because I was wondering about it, and it relates to that question and to what Charles was just saying. You mentioned that there are concerns within the law about people giving away their property before death in an attempt to evade taxes in order to make sure there's nothing left in the estate. I wasn't, and I'm still not entirely clear on how that's evaluated. But as Charles mentioned, one of the ways of dealing with inheritance issues within Jewish law, to try to write a will that will not run afoul of Judaism's insistence that you can't give a gift after death, is to give an inter vivos gift and to say, well, I'm giving it to this one and to this one and this one, and it will be valid a moment before death. Now, there are weaknesses in that method within Judaism and Jewish tradition in its own right, but my question is, how will the law look at that if the law doesn't want people emptying out their estates before death? Even though it's clearly not done to evade taxes or whatever, it's being done to satisfy religious expectations.
Kim, why don't you just come up to the podium, please?
Sorry, I know you thought you were done.
I almost forget the question now. Is this one on? Can you hear me? Nobody wants to hear my answer. I'm just going to sit down now.
Oh, the battery's off, that's why.
Archie.
Nobody has ever said I'm not loud enough.
The podium mics. Now it's working.
Okay, so now I forget the question. I think if you, in those circumstances, were to give away your property prior to death and you did not defraud creditors or others, and you provided for your dependents and your spouses, then there would be no need for a claim, right? Mm-hmm. So I guess presuming that you did the right thing when you gave everything away during your lifetime, then
right. And if one of the heirs, or one of the ones who was supposed to be an heir, decided to bring a claim and use this as their justification?
Yes, well.
But an heir isn't a creditor, and the question